Right. Good morning, everybody, for the final time. Thank you for your patience and for waiting. My name is Harry Dyson. I'm a member of the Business and Property team at King's Chambers, and I will be presenting this talk today, an introduction to penalty clauses. Just from the outset, to be clear, not to disappoint everyone, that's exactly what it will be. It will be an introduction. It's going to be a broad overview of the doctrine. If you've attended hoping for a detailed analysis of the finer points of the law or some cutting-edge breakdown of some of the latest judgments, unfortunately, you'll be disappointed. The purpose of this talk is really, I was thinking about the real takeaways that I hope there to be from today, and that's to aid you as practitioners in the art of spotting potential penalty clauses. And I emphasize potential because as this talk will hopefully demonstrate, it's often not possible to be absolutely certain that something is a penalty clause or isn't. But as I say, this should help you in spotting potential clauses. The reason why this is important is because often these clauses are hidden away within the parties' standard terms and conditions. Now, we're probably all painfully aware of the difficulties and the discomfort, frankly, of trawling through long terms and conditions that are often exchanged by parties. So it's important that when we're skimming through these, which sometimes we have to do when we're advising in conference, for example, it's important that we have the skills to spot these potential clauses easily. Well, that's the idea anyway. So hopefully we achieve that. So here we go on to the first slide. Right, so what is a penalty clause? That's the key question. And I think that the key basis to today's understanding this almost binary distinction that exists in the law. So if we steal a section from Chitty, where the parties to a contract agree that in the event of a breach, contract breaker shall pay to the a specified sum of money, the sum fixed may be classified by the court as either a penalty, which is irrecoverable, or as liquidated damages, which are recoverable. So in short, liquidated damages clauses are okay, no problem, but penalty clauses are irrecoverable and a judge is not going to let you get away with relying on them. So without delving too much into jurisprudence or legal theory or all of that sort of thing, it's important to identify here that there's clearly a friction in the law here. On the one hand, we have this idea of freedom of contract. So parties can agree between themselves to anything as long as it is illegal and they are bound by those terms. And of course, if it is a liquidated damages clause, this gives the parties certainty. One party says to another, look, if you breach this contract, you have to pay X amount of money or do this thing. Everybody knows what's going to happen if they breach, and as a result of which, the parties have some certainty. And that is almost always a good thing. This, certainty of contract is a doctrine in and of itself. And I think we can all agree that generally speaking, that's something that should be aimed for. So we contrast that with what this doctrine does, which essentially says, no, we're not going to always let the parties simply sign up for contracts and whatever it says goes. There is this contract of penalty clauses which are irrecoverable, and of course this goes in the face of freedom of contract. So this is why it's important to bear in mind. But this is really why it's difficult often to prove that something's a penalty clause and to convince a court to go against this idea of freedom of contract and hold it to be unenforceable. That's a crux of it. Looking at some basic principles, really, of which there are two really, really basic principles. The first one is that it's a question of law. By that I mean there's nothing really to enable the parties to decide that something is a penalty clause with any certainty, absolute certainty, until a judge decides so at trial or in some preliminary hearing that's binding. So these terms until trial, that for want of a better phrase, roam wild and free, often hiding away the little scamps in the standard terms and conditions, and that's where they are. So that's important to bear in mind, that really this is a question of law, and it's not possible for the parties to say with any absolute certainty until a judge has decided either way. The second point, which is important to bear in mind as we go through the various analyses is that the court will look at all this when at the date on which the contract was entered into. So not the date that it was breached, not the date which you find yourself on your feet in court, but when the parties signed on the dotted line or shook hands or whatever else and agreed to the contract terms. This, depending on the factual background of the case, as we'll go into during this presentation, can be very important because, of course, things change. The third point, which isn't on the slide, but I thought best to flag up, is that this is a completely separate consideration to whether or not your client may be saved or indeed hindered by other things such as the Unfair Contract Terms Act and any other contractual mechanism as to why a clause can be avoided. So this is simply one string to your bow and how you may get your client in or out of a contractual obligation. So of course we need to look at what the test is for penalty clauses, really, what we can rely on in court to argue it either way. That authority is in the form of Cavendish Square Holdings and McDessie and Parking Eye and Beavis. Now these were joint appeals to the Supreme Court by a 7-justice panel. It's fair to say this is the leading authority in this area, and it's not too much of a stretch to say that if you only ever read one judgment and this was it, you would be able to handle many, perhaps most cases involving penalty clauses. Again, that may be a stretch with the more complicated one, but generally speaking, it is a fantastic judgment, which is very helpful. And as we all know, it really is good to have all the law tied up in one neat Supreme Court judgment that everybody can rely on and everybody can use at trial. So in that respect, we are very fortunate. Now, there's issues which we'll explore later on, but as I say, we are very fortunate to have such a definitive judgment in this area. So if you were only to do one thing following this talk, I would recommend you read this judgment, and as I say, after that, you'd come away with a relatively full understanding of the framework of this doctrine. So the facts of these cases then, we have Cavendish Square Holdings and McDessie. So I should say out of the two cases, this Cavendish and Parking Eye, Cavendish is very much a heavy commercial dispute, whereas Parking Eye, as we'll find out, and as may be obvious by the name, is more of a day-to-day thing that many of us may find ourselves involved with. So starting with Cavendish, that the crux of it is as set out on the slide. McDessie agreed to sell Cavendish the majority of his shares in a company. As part of this sale, he contracted to not compete with the company once the sale had gone through, which, fair enough, it's very common, non-compete clauses as they're often called, so nothing unusual there. The contract went on to say that if he did compete, there would be essentially two consequences. The first one was that he wouldn't be entitled to receive the final 2 installments of the purchase price. And the second one, which was a bit more novel, was that he would have to transfer his remaining shares that he hadn't sold at a lower price. This lower price, it was said, excluded the value of the goodwill in the business, because obviously had he gone and set up shop elsewhere competing, the goodwill really would have gone with him, and therefore the business was worth less. That was the rationale. So we have two clauses, and we'll come back to these clauses sort of throughout today's talk. So keep that in mind, that there really was two limbs to the consequences for McDessie for setting up in competition. Of course, it won't go to surprise any of you that it was argued that these two clauses were penalty clauses. The second case, as promised, it's perhaps more relatable to many of us. Parking Eye run car parks which serve retail parks. Car parks, like often they do, had a 2-hour limit. It was free to park, but you can only stay for 2 hours. These are often seen in service stations on the motorway and the like. And if one did overstay, you were liable for an £85 fine. Mr. Beavis, in fairness to him, only stayed for 2 hours and 56 minutes. That was sort of the crux of his moral issue with the case. But anyway, he argued that it was a penalty clause. And we'll come on to the results of both of those cases towards the end. There has to be some element of suspense with this morning's production, so please bear with me, but at the very end, we'll circle all the way back and have a look at these two cases and, well, more likely the result of them. So as I say, this judgment is very good because it gives us this test. A true test is whether the impugned provision is a secondary obligation which imposes a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. So this, with aid of some of the sections of the judgment, can be broken down really into three stages. The first one, is the clause a secondary obligation? Secondly, is it a legitimate interest, commercial interest in deterring the breach, or either does such an interest exist? And is the amount extravagant or unconscionable in proportion to that interest? This is the main takeaway from the case, and the really is the most important section of the judgment, as you'll gather. So secondary obligation, what do we mean by that? Well, helpfully, again, the judgment defines this. If the contract does not impose expressly or impliedly an obligation to perform the act, it simply provides that if one party does not perform, he will pay the party a specified sum. The obligation to pay the specified sum is a conditional primary obligation and cannot be a penalty. That is a bit of a mouthful, as you've probably heard me butcher it there. So really, the most straightforward way of distilling this, and it is an oversimplification as we'll come on to, but really if a contract, rather than saying that's a breach, this is the consequence, if it gives an option and an option for that party to take, but says if you take that option, this is the consequence, it's not a secondary obligation, it's a primary obligation. So the best example I could think of is a PCP deal on a car. Many of us will have probably had them, and the crux of them is really set out in the contract clause that I dreamt up on one slide there. So at the end of the PCP term, the customer can return the vehicle to the dealer or pay the balloon payment as specified in the terms of this contract. So it does what it says on the tin. You either keep the car at the end and pay the balloon payment, which is set out at the outset of the contract, or you hand the car back and walk away and, well, often sign on to another deal in a similar vein. But you walk away with no obligations, and that's the choice that customers are given in those situations. I say that I don't think there's been a case on this, but I say clearly the payment of a balloon payment cannot be a penalty clause, as it's not a secondary obligation. Clearly, there's a choice here that the parties have, and if one exercises the choice to keep the car, you pay the balloon payment. So it's a conditional primary obligation, as was envisaged in the Cavendish definition, and it's not a penalty clause. Brilliant, you may think. How is Harry going to spend the next 20 minutes or so discussing this doctrine if it's as simple as that? But unfortunately, it isn't. So Cavendish is a really good example. Here, their lordships, in terms of the first clause, which was to circle back, that if you set up and competed, you would not be entitled to the final 2 instalments of the purchase price. 3 of their lordships found that this actually was not a secondary obligation. They found it to be a price reduction clause and a conditional primary obligation. So they basically said the choice was there, and that's what McBessy took, and that was a primary obligation. Therefore, it's not capable of being a penalty clause because it doesn't get over that first hurdle. The remaining 4 lordships disagreed. They said, no, it is a secondary obligation, and it is capable of getting over that first threshold and capable of being a penalty clause. I'd recommend you read the judgment. It really is thrilling reading, but it goes to demonstrate really how unclear this issue can be. So whilst in the realms of a PCP deal on a car, really straightforward, in a contract such as Cavendish, it often really isn't straightforward, and it's important to properly look at it. So the takeaway is this. In my view, perhaps it's just me, it's easy to get to go straight to the second half of this test and say, well, the sum of money you want is ridiculous, it bears no relation to your loss, etc., etc. But it's important not to skim over this first point, whether or not it's when you're defending a claim or, pursuing a claim. It's important not to skim over this point and to give it proper consideration. Unfortunately, often that will mean really trawling through contracts, going through clause by clause and doing some sort of forensic examination into what is and isn't their primary obligation. But unfortunately, that's just the nature of the beast. But hopefully, this demonstrates that it's not always straightforward. The next point is if when arguing that something is a penalty clause, you're able to establish that it is a secondary obligation, you then will have to convince a judge potentially that there's no legitimate interest in deterring the breach. Or if you're wanting the clause to be enforced, you will want to say, look, there is a legitimate interest. The first point is and this cannot be stressed enough. Punishment is not a legitimate interest. It may seem obvious, but your lay clients may not want to grasp the point. But yes, you're deterring something, and punishment is a fantastic way of deterring people from doing things, but it's not a legitimate way of doing so in the eyes of the common law in this doctrine. So anything that is simply a punishment, you can be relatively confident that the judge will throw out as being a penalty clause. But there are some hallmarks of what courts will look for to see if it is a legitimate interest. Now, I say hallmarks because this isn't an exhaustive list, and really it is case by case basis that judges decide this on, and really fact sensitive. So always bear that in mind. Don't walk away from today having read the slide thinking, well, there's those 5 pillars of legitimate interest, and if I don't fit neatly into one of those, we don't have a legitimate interest. Don't do that. Simply see these as great examples, proven examples of when there is a legitimate interest. If we take just a couple of them, difficulty in proving loss, the parking eye case is actually a fantastic example of this. So the loss that was said there was these car parks rely on a high turnover of cars, different people coming to use the businesses within the business park, and that's how they make their money. They wouldn't make any money if it was simply used as a car park, some offices around the corner, and people park there all day, every day. Fine. But how do you go about proving that loss? Does every customer buy the same amount of product from each shop every time they visit? Of course they don't. It's very difficult to prove. So, if we're setting the parking eye case, there's a legitimate interest because we couldn't possibly start proving the loss for each breach of this term. So therefore, there's a legitimate interest in putting any round figure on it, in this case, £85. And their lordships in the parking eye case were fully in favour of that and found that to be a legitimate interest. So that's one example that you can really translate to many different cases. The second one we'll look at, substitute not available. Again, this can be a very straightforward one. It's not difficult to imagine such a situation. You contract with somebody for the hire of something, of which there's only one in existence. There's a legitimate interest in ensuring that contract is in fact fulfilled. Loss suffered by a third party. This one can be a little bit more complicated, but again, we're back to the parking eye case. They said, well, the contract is between us, parking eye, and the driver, but the loss will actually be suffered by, in the first instance, by the retail park, or rather the tenants thereof, the businesses. So it's difficult for us to prove that loss or even have standing to bring a claim for that loss. So there's a legitimate interest in us putting a round figure on it. Around and round we go. So you can see there that it's possible to define, as I've tried to do here, different categories where there is clearly a legitimate interest. But like I say, they're not exhaustive, but they are simply a good framework on which you can think about whether or not your client has such an interest. On to the final limb, which is the one that often people want to jump straight to, is the amount extravagant or unconscionable in proportion to that interest? Again, case by case basis, this is decided on, and that is why it really is difficult to advise on. It must not, as a general rule of thumb, be substantially more than is required in order to defer the defendant breach. So again, if we think back to the Parking Eye case, £85 isn't really substantially more than is required, because all of us would wince at receiving an £85 penalty fee through the post, whereas if it, for example, was £500, we may well keel over. That's quite different. So that's a good way to think about it. The last point I make here is that if it is a genuine pre-estimate of loss, and your client can go along to trial and say, we've worked this out, this is how we've come to that figure, there it is, that's going to be fantastic. Really, really is going to be fantastic evidence, and it's really probably going to get you home on this point. But that it's not necessary to be able to do that. Now, I'm not going to drag us down a rabbit hole of going through the history of this doctrine and how it developed. That's probably a talk for another day. If anybody would be interested, you might not be. But the law's moved on, and it doesn't require now any threshold requiring a genuine pre-estimate of loss. So there's no requirement for that. It's important I emphasize that. But if you think your client can evidence that it is a genuine pre-estimate, or even if they can show, look, we've made inroads into trying to estimate it, and that's how we've come to this figure, it will always be very, very helpful. So bear that in mind. So whilst I don't think it's important to go through how the doctrine has developed, it is helpful to flag that, because it shows what would really be not quite a silver bullet, but it would be incredibly helpful. So now we've worked through the three pillars of the doctrine. I thought it'd be good to work through two examples. The first of which came from a case that I've handled myself. The second one is a bit more fanciful, and it's one that I dreamt up when making this presentation, as might be obvious. So the first example, I'll give the case back before we run through what the clause says. The claimant was a surveyor who provided services to my client, the defendant. The defendant owned and ran some colleges, so various different big buildings. And what the claimant did was come along to the defendant and say, right, we will do various surveys of the properties and put together a case which we send off to the relevant authorities, and we convince them to reduce the rateable value of your properties, which in turn will reduce the amount of rates you will pay. Thereby, there is a value to the service provided. The actual mechanics of how they do that is far beyond my understanding, but what they were doing is basically coming along, providing a service which would secure the defendant a benefit. So relatively straightforward. The claimant, the facts of the case were that the claimant failed to make any progress after a very long period of time. The defendant grew frustrated and essentially rang up, as you might expect, and said, look, we're not getting anywhere, we're cancelling, we're going down the road, and we're going to use so-and-so, your competitor. The claimant, quick as a shot, knocked up an invoice and sent it to the defendant, and that was the basis of his claim. And he relied upon the clause on the slide. We understand that in the event of a cancellation, we will be liable to a cancellation fee equivalent to 2% of the rateable value of the subject property or properties. So as you can see, it does give a sum, but it's a sum that's tied to the value of whatever properties the claimant was working on. As you might expect, 2% of the rateable value of a property is a significant amount of money, and in this case, it was significantly more than the full contract price. From memory, it was something getting on for double. It wasn't a crazy sum of money, but it was, almost double what the full contract price would be had the claimant actually gone ahead and done all the work. So as you can expect, and you'll have to forgive me for boasting for a moment, but yes, I argued it was penalty clause, and the judge was with me on the point. So let's break down why that was a successful argument. The first one is, yes, it was clearly a secondary obligation. There was no argument that it was a primary obligation. This was a cancellation in breach of the contract. It would have been argued. So that the secondary primary obligation point didn't really feature. I'm not saying it couldn't have done by some argument, but in this case, it didn't. So the second leg was whether or not there was a legitimate interest. Of course, a concession what one would have to make is there is a legitimate interest in people protecting themselves from parties cancelling when they've already commenced work and incurred fees. Fine, there was no getting away from that. But I argued that there was no legitimate interest in a clause that prevented the defendant from terminating the contract under any circumstances and being hauled to ransom effectively for this 2% value. What it represented was a wholesale ban on cancelling the contract, no matter what happened. And I said that there's no legitimate interest in that being the case. And we had to look at the contract when it was formed, of course, at the time. There was nothing in the contract that said how long the works might have to take. So there was nothing that held the claimant to account on how long he might take to complete, nor were there any representations given by either side or claims to be given by either side as to how long it might take. So in the circumstances, it really was open-ended, and I was able to capitalise on my submissions and say, look, there's no legitimate interest here whatsoever in holding the defendant to ransom for such a period of time and preventing him essentially from going elsewhere. The judge was with me on that point, and the third limb, which you'll expect was easier to overcome, the amount claimed was clearly extravagant and unconscionable to the legitimate interest. Basically, because it was more than the full contract price had he done all the work, which we say he'd done pretty much none of it. But pausing there, remember there's no need for it to have been a genuine pre-estimate of loss, because he may say, well, I would have perhaps gone over my fee estimate, but it was clearly extravagant because it's more than what he would have been entitled to be paid in full, and it was clearly unconscionable to charge more for having not done the work in full than would have been charged if he had a satisfied customer going away very happy. So hopefully that shows broken down how a real life example can be tackled in court and defeated ultimately. The second example, like I say, is one I've dreamt up. The idea is that a business contracts with a courier for the delivery of a product. The clause reads, in the event of a delivery being delayed by over 24 hours, the courier shall pay the customer a sum equivalent to 50% of the value of the shipment. At first glance, secondary obligation, there's a legitimate interest if things are being delivered on time, but the sum is clearly extravagant and unconscionable. That's on the face of it, but this shows hopefully that we need to delve deeper. Was the contract for one specific item that both parties knew the value of? Did the contract specify why it had to be delivered, or representation specify why it had to be delivered in time? It may well be established that this is enforceable, and of course, on the face of it, we don't know the value of the shipment. So whilst this does seem a fanciful equivalent, fanciful clause, and one that certainly the likes of DPD wouldn't sign up to, it may well be enforceable. So to finally end the suspense of what happened in these two cases that I've referred to, in both cases the clauses were found to be enforceable. So in Cavendish, in the first clause, which again was relieving Cavendish of the obligation to pay the remaining instalments, whilst it was found by majority that it was a secondary obligation, it was found that it was proportionate in protecting our legitimate interest. And the second clause, which was that McDessie had to sell his remaining shares at a lower value, they found that that was a primary obligation, but they still went on to rule that there was a legitimate interest and so on and so forth. So this is an interesting element to the judgment, and it's not one that's possible to analyse with any certainty, but I think it really goes to show that perhaps their lordships weren't certain in defining it as a primary obligation, and it's perhaps not the strongest basis, not the strongest part of the authority to point to when arguing the primary secondary obligation point. But there we are. That's where their lordships finished up with that point. Secondly, Parking Eye. This was found to be a secondary obligation, as you'd expect, and capable of being a penalty clause. But as I think I probably alluded to, there was found to be a legitimate interest, and £85 was proportionate to that interest. So that clause was also found to be enforceable. So the next slide is about the scope of the doctrine, but just to round off the main body of this presentation, hopefully I walked everybody through in slow enough terms the basis of the doctrine, the three-stage test, and pointed out some of the areas that really require some intense consideration because they're more complicated than may appear on their face. So I have two slides left, this one and the remaining one, which frankly complicates matters a little bit further, but they're hopefully not too much. This slide, the scope of the doctrine, is just to really put up in light that the doctrine doesn't only cover clauses that say X amount of money is payable upon breach. It can be deployed much wider than that. Any adverse consequence for a party upon a breach, you really ought to be thinking penalty clause and whether or not you can rely on the doctrine to avoid it. Or indeed, if you're trying to enforce it, again, you need to think penalty clause and see if you're going to be able to convince a judge to hold it enforceable. The final slide is perhaps what would be a good introduction to a further talk into this concept of disguised penalties. The concept, or rather scope for discussion, comes from the case of Interphoto Picture Library, the facts of which, as on the slides, the defendant hired slides, which I'm told is what he did in the late 80s. The claimant charges a much higher rate if the slides were not returned within a fixed period. So they charged X pounds a day if they returned on time, and then X plus 5 if they weren't. Now, in this case, it wasn't actually argued that a penalty clause should be considered, but that didn't stop Lord Justice Bingham going slightly off-piste and starting to discuss this, where there may be a category of disguised penalty clauses. And I think this is important just to touch upon, because I think it's fair to say that since Cavendish and Parking Eye judgments, that the people drafting contracts are becoming more and more alive to this concept, and in short, are finding very clever ways of packaging up clauses to make them appear as primary obligations, to make them immune from this penalty clause doctrine. I'm sure you can imagine how they may do that, but believe me, when you see one that's capable of being a disguised penalty clause, it is sometimes quite impressive how they've managed to package it up. So, whilst I'm not saying there is a whole limb of this doctrine, disguised penalty clauses, that's well known and has been well explored in judgment, it is worth keeping one eye on, and keeping an eye on this judgment as food for thought. If down the line you find a clause that's really hidden up and packaged as a primary obligation, but you really do suspect that in fact it is a secondary obligation and ought to be considered as a penalty clause. So as I say, I'm conscious time's getting on, and I won't get us bogged down in this offshoot of the doctrine at this point, but I did want to put it on everybody's radar that it is worth considering. And likewise, if you find yourself advising on the drafting of the contract, it may well be open to you to consider how you can package things up as primary obligations rather than secondary obligations, and keep this clause in mind at all times. And this is, I'll concede I forgot about this slide. This is what Lord Bingham had to say. In reaching the conclusion I have expressed, I would not wish to be taken as deciding that Condition 2 was not challengeable as a disguised penalty clause. So this really shows how far the judgment gets. It was simply Lord Justice Bingham going slightly off-piste, saying that this ought to be considered, but was perhaps a nod to the advocates that they forgot to do something they should have done. So, again, just something I'm putting on your radar, and not something we're going into in detail at this point. So just to quickly go to some of the questions that have been helpfully put in the chat and the Q&A. So the first one is, will the slides be available after? That's an easy one to answer. Yes, I'm confident they will be available. If you get in touch with one of the clerks, they'll happily send them over. Secondly, does there have to be a choice? again, this is a complicated area of the law. I don't think in terms of primary or secondary, it's as simple as saying, as I've tried to boil it down, that it's going to say you can either do A or B. The choice is often going to be hidden in much more sort of opaque terms. But I think generally speaking, if one is to argue that it's a primary obligation, there has to be at least strong grounds for saying, look, there's clearly two avenues the parties can go on here, and it isn't a secondary obligation. So, and I think it's a difficult question to answer sort of in the abstract. It really is quite case specific. Apologies if that's dodging the question somewhat. So we've had another question in terms of the PCP deal, and that was if the fee for not returning the car was extravagant. For example, I think 1,000 is put in the question. Could that be said to still be a primary obligation and avoid the clause altogether? Yes, I think it would be perfectly arguable to say, look, it's still a primary obligation, therefore it can't be a penalty clause. But I think that circles back neatly to what Lord Justice Bingham was envisioning, in that there will be these hidden clauses. So in that case, that is the exact sort of case. So we go to take the car, we want to keep the car, but it actually costs £1,000, say for a Renault Clio, as the example given. We would be saying that's clearly a hidden penalty clause and ought to be dealt with within the doctrine. So I think that is a very good question. Thank you for that. So yes, and again, I think would you mind emphasising the difference between primary and secondary obligations? How do we spot the difference? Yes, again, I think we're all homing in here on one of the more complicated elements of this, and it really is difficult, and again, case specific. So unfortunately, that I'll have to give a very caveated answer, as counsel sometimes does. But if we look back at the Cavendish case, that's a good example of how difficult it is. We had 4 lordships on one side, 3 on the other, who really come to grief as primary or secondary. So I don't think there's actually a real accurate test that can be deployed to spot the difference. It really is a case of reading the contract, using the usual terms of, the usual ways of construction, and looking at really what appears to be a consequence of a breach. That's one of the hallmarks. If it clearly is a breach of the contract, that will get you a long way in establishing that it's a secondary obligation. But again, we could have said that in the Cavendish case about competing when he agreed not to. So that shows it really isn't as easy as it could be to define the two. So unfortunately, that's probably the best I can do in terms of giving any definite guidance on the point. Thank you, everybody. That's probably all the time for questions I've got time for. I'll have a scroll through and get back to anybody I've missed, but I'm conscious not to keep anybody on too long. So thank you, everybody, for joining, and any questions following this, by all means, please do get in touch in chambers. Thank you.